Draw near, you attended to yourself and heard. Please be seated.
Good afternoon and welcome. Before I begin the call of the calendar, it is the tradition of this court and the distinct privilege of the JP to welcome new members of our court. Today, I am beyond thrilled to be able to introduce to you my Bronx brother, the Honorable Julio Rodriguez III. Justice Julio Rodriguez attended John Jay College of Criminal Justice, graduating cum laude in 1995. He went on to earn his Juris Doctorate from Temple Law School in 1998. Justice Rodriguez began his legal career as an assistant district attorney in New York County and then served as Inspector General for the New York City Department of Investigation. Before joining the bench, Justice Rodriguez served as Executive Director for the Environmental Control Board and Deputy Commissioner at the New York City Office of Administrative Trials and Hearings. He served in that capacity until his interim appointment in 2013 to the New York City Civil Court and was immediately assigned to the Criminal Court. 4 years later, he was designated an acting Supreme Court Justice and served as Deputy Supervising Judge for the New York City Criminal Court, Bronx County. In 2018, Justice Rodriguez was elected to the New York State Supreme Court, Bronx County. Thereafter, in February 2020, in recognition of his incredible leadership, he was appointed Administrative Judge for Criminal Matters in the 12th Judicial District, Bronx County, where he served until his appointment to this honorable court. Welcome, my friend, and again, congratulations. And now for the call of the calendar. Thank you. Okay. Now, you know the drill. I have over 6 hours of requested argument time. So, please ask for what you need in terms of time, not what you want, okay? Please understand that the time is for you, not for us. If we think in the middle of argument it requires more questions and more time, we will keep going. So please just ask for what you need. People versus Marvin Patterson.
Good afternoon, Your Honor. Appellant request 5 and 2.
Okay, 5 and 1 and 5. Villatala versus Con Edison. Thank you so much. R. Kensington is submitted. Fatahu versus New Jersey Transit Corp.
Good afternoon, Your Honor. Appellant request
5 and 2 for appellant, 5 for respondent. People versus Jose Lozada. That's a submit. Gould versus Jewish National Fund.
Good afternoon, Your Honor. For the appellant, request 8 and 2.
Appellant 4 and 1, respondent 4. Jones versus O'Neill. Appellant 4 and 1, respondent 4. Brembo versus TAW Performance.
For the appellant, Your Honor, 10 plus 2.
Respondent? 8 minutes. Appellant 6 and 2, respondent 6. People versus Sean Woodward. Submitted. People versus Antonio de Jesus. Submitted. Needleman versus McFadden is submitted. Matthew versus Linnea.
For appellant, Your Honor, I
You got it, 3 minutes. Empery Asset versus AIT Therapeutics. How much? 7 and 2 and 9. Lanzau versus Deval Transit is submitted. Adika versus New York City Transit Authority.
Good afternoon, Your Honor. Appellate request 8 and 2.
Counsel?
Respondent request 5.
Okay. Appellant 5 and 1, respondent 5. People versus Jamal Hicks. Submitted. People versus Elvis Montero. I guess Elvis is not in the building. Miller versus Mount Sinai Hospital. I'm sorry? 6 and 2. Okay, respondent?
5 minutes, Your Honor.
5 and 1 and 5. U.S. Bank versus Chait.
For U.S. Bank, Your Honor, the respondent will request 3 minutes.
You got it, 3 minutes. Submit for respondent. People versus Cedric Reed.
Respondent 6.
5 and 1 and 5. Samanovic versus Kingsbridge Realty is submitted. Gamma Lending versus Kaminsky is submitted. First case on the calendar, People versus Marvin Patterson. You may proceed.
Good afternoon, Your Honors, and may it please the Court. Matthew Christiana on behalf of Mr. Marvin Patterson. Mr. Patterson was sentenced to a term of 8 years, followed by 5 years post-release supervision for an incident that occurred when he was 24 years old. What we are requesting here is a 1-year reduction to the minimum of 7 years, which is still a substantial punishment and a long time, especially for Mr. Patterson. Were he to serve that term, upon its completion, he would have spent nearly a quarter of his life incarcerated on the current offense alone. This was a young man who had an extremely difficult upbringing, who spent the majority of his formative teenage years without the structure and resources for support that are often so indispensable for a young adult. Mr. Patterson also battled with serious mental health issues at a young age, which ultimately culminated into suicidal ideations just years before the current incident. And by the time of this incident, Mr. Patterson was going through a turbulent time and an emotional time in his life. He was struggling with the possibility that his relationship was coming to an end, and when he arrived at the apartment, which he called his home, he noticed the door was locked and he reacted. In essence, Your Honors, this was an uncharacteristic offense for Mr. Patterson, born out of emotion. It was an emotional-driven lapse of judgment, and 7 years adequately accounts for the nature of this offense and also considers the mitigating factors present here. And I would also just like to note that whenever Mr. Patterson is released, he would still be subject to 5 years post-release supervision. So there will be substantial oversight upon his release. And if there are no questions with respect to Mr. Patterson's sentence, I would like to just briefly turn to Mr. Patterson's in absentia claim as well.
Okay.
Sure. Mr. Patterson was denied his right to be present when he was sentenced in absentia. He did not forfeit nor waive this right. Mr. Patterson's voluntary absence did not exhibit a defiance of the process of law.
He walked out in the middle of the sentencing proceeding, didn't he?
Yes, Your Honor, he did walk
So
out.
how did he not have complete control over his own actions?
Your Honor, he certainly did, but in this case, Mr. Patterson did not leave in defiance. Instead, he left with the permission of the court. He stood up, expressed his frustration, expressed a desire to leave, and the court expressly granted him permission to do so, and he did not leave until after permission was granted. And that's what separates this case from the forfeiture cases that were cited.
Well, it wasn't like he asked for permission to leave. He said, I'm tired of this, I'm leaving. And the court didn't stop him.
Your Honor, he did express that frustration. He was...
Counsel, he would have been better off not coming to the courthouse, because didn't the court say that prior to this proceeding, that if you don't show up, I'm going to increase your sentence and whatever, but he would have been better off not showing up then, I guess. Then he would have had a better, then your argument about extension would have been a little bit stronger.
Your Honor, that's correct. The plea court did inform Mr. Patterson that any consequence would be an adjournment for about a week or so for him to reconsider, and then a higher sentence as a result, which is important in this case too, because that's the extent of the information that Mr. Patterson had when he walked into that courtroom. At no point was he informed that this proceeding could continue in his absence. He walked in there with the belief that the case could potentially be called again.
This was not his first foray into the criminal justice system, correct?
Your Honor, it is not, Your Honor.
So he's not a novice. He's a second felony offender. A violent felony offender at that, right?
Yes, Your Honor.
Okay.
Yes, the most recent previous offense was when he was 19 years old, and it's unclear what colloquy surrounded any sort of sentencing proceeding during that proceeding. So as far as this record is clear, is that Mr. Patterson only knew that a consequence could be a second appearance and a higher sentence as a result. And that's importantly what separates this case from the forfeiture cases cited in the briefs. In those cases, specifically People versus Sanchez out of the Court of Appeals. And
what makes you say that it's clear from the record that all he thought could happen was that there would be a second call? What is there in the record that would support that statement?
Your Honor, the only, up until the point that Mr. Patterson arrived at the sentencing proceeding, he was told the information that was relayed upon to him was from the plea court. And the plea court never insinuated or explicitly told him that sentencing could proceed in his absence. So in terms of consequences, there was the adjournment and the imposition of a higher sentence. So that's what we know, at least in this record, that Mr. Patterson was informed of.
So you want us to come up with a ruling that says that if a defendant voluntarily absents himself in the process of sentencing, walks out, that requires the Supreme Court judge to second call the case whenever the defendant wants to come back to be sentenced?
Your Honor, I see my time has expired.
You can answer my question.
Not necessarily, Your Honor. In this case, though, Mr. Patterson was informed that that would be the result of any sort of absence, and Mr. Patterson left with permission with that knowledge in mind. So in this case, the court could have done so.
Okay, thank you.
Thank you, Your Honor.
Counsel, I'll hear you now.
Good afternoon, Your Honors. John Hughes for the People. I'd like to start by addressing the excessive sentence claim in this case. The underlying facts here are really quite serious. Defendant's girlfriend was trying to break up with him, and because of that, defendant broke down a locked door to the apartment that his girlfriend was staying in. He attacked her with a knife. He beat her with his fists, leaving her lacerated, bleeding, and bruised. After his arrest, there was an order of protection issued in favor of his girlfriend. Defendant repeatedly violated it. He called the same girlfriend that he had just attacked, said that he would break her face if she hung up on him. She told his girlfriend that he was going to kill himself if she broke up with him, obviously to try to manipulate and control her. And he even cajoled his girlfriend and then another woman too into following a false ACS complaint against one of the witnesses in this case to try to intimidate them and prevent them from testifying. So while the defendant keeps saying this is, some emotion-driven lapse of judgment, between all of the underlying facts we have here, and also his, fairly significant criminal record, not many convictions, but serious and violent ones, I think really the record shows that, he was a controlling serial abuser. And so the underlying conduct here was already very, very severe. And nonetheless, he got a really good deal. Originally, he was charged with burglary in the first degree. I was going to have a minimum sentence of 10 years, maximum 25. But because of this negotiated plea agreement, he got to plead to a lesser charge and receive a sentence of only 8. It's only 1 year above the minimum sentence. So given all the aggravating factors in this case, we think a sentence of just 1 year above the minimum was absolutely appropriate.
Why don't you address the issue of the sentencing in absentia?
Absolutely, Your Honor. So essentially, at the sentencing, defendant said that if the court didn't let him go, then he was going to force the court to remove him. He also said that he wasn't going to listen to what the court was going to say. At that point, the court, said, "Okay, take charge. He's excused. We will continue the sentencing in his absence." So I think, as Your Honors were pointing out, this is clearly a situation where defendant forfeited his right to be present at sentencing. And I think also he waived it since there's a record support for the fact that he was warned that the sentencing was in fact going to continue in his absence. And as Your Honor pointed out too, this wasn't his first time in a criminal court, so he obviously had at least some amount of familiarity with these proceedings. And if this court doesn't have any other questions, then I'd like to rest on our brief and ask that you affirm.
Thank you.
Thank you.
Okay, counsel, I'll hear from you again for a minute.
Thank you, Your Honor. Just briefly to address the sentencing point here. What's important about this case and the actions of Mr. Patterson is that there was no, Mr. Patterson didn't abscond, which the cases cited in the briefs below, as far as forfeiture is concerned, cases like People versus Sanchez or People versus Halls, where the defendants absconded in general. They failed to appear, and that conduct was sufficient to effect a forfeiture because they were essentially unambiguously just frustrating the proceeding as a whole, which is not what occurred here. And Mr. Patterson, he did stand up. He said, "I don't want to be here. My family's not present for any of this." I think the first thing that he said was, I want to leave, or something to that effect. Then he said, "You're going to remove, or am I going to be removed?" But again, Mr. Patterson did not exhibit any conduct other than that statement. And afterwards, he left with permission from the court. And with respect to waiver, I see that my time is up. May I just briefly?
Briefly.
With respect to waiver, there is a sentence in the transcript on page 3 that says, "We will continue in the defendant's absence." But as discernible from the record, Mr. Patterson was not in the courtroom at that point. Every time Mr. Patterson was in the courtroom, the court addressed Mr. Patterson directly, and even still, if he was, it is certainly not sufficient to adequately apprise him of his right to be present, especially with the conflicting information that he received from the plea court. Thank you, Your Honors.
Thank you. Mr. Christian, you're Mr. Christian, correct? Okay, and you appeared today under the student practice order. You're a law graduate, as I understand. I want to thank you for your work today, you as well. But I just wanted to say I hope that you will be admitted soon, and you did a good job.
Thank you so much.
Thank you. Okay. Fatou versus New Jersey Transit Corp. And if I'm mispronouncing the plaintiff's name, please forgive me.
If I may begin.
You may proceed.
Thank you, Your Honor. May it please the court, Dean Pillarella for defendant appellant. Because transit's participation in
All right,
discovery.
counsel, I have to get right to this because I was on the bench for Belfan
Yes,
versus
Your Honor.
Potoso, right? So first of all, it's just not the same bus driver, is it?
There is no bus driver in this action, Your Honor.
Oh, okay, because when I looked at the answer, it said counsel for Raymond Potosa, and I'm like, is the same bus driver involved in this case? No.
Well, the predecessor counsels in those two cases were the same.
Were the same,
And,
okay,
and then we subsequently took over for the
That's
appeals.
probably what happened here. Okay, terrific.
So there is no bus driver in
So
this.
let's get right to the heart of this.
Yes, Your Honor.
You know, Hyatt changed the landscape without question in terms of sovereign immunity, the consent part. That's no longer, according to Hyatt's decision, it's got to be explicit and clear. A sovereign state has to explicitly and clearly consent to being sued in another state.
Yes.
That's what Hyatt said. No bones about, no, there's no question about that. And the full faith and credit really now is off the wayside because full faith and credit was the basis for Hall. Hall's decision, which was back in 1970, 40 years earlier, had to deal with full faith and credit.
Yeah, well, yes, it did, Your Honor, but the full faith and credit clause, we argue, is implicated anew.
Not on Hyatt. Hyatt 3 does not talk about full faith and credit. In fact, Justice Thomas made specifically said, we never had the chance to talk about consent because In Hyatt 2, we talked about full faith and credit, and that had to do with the judgment in terms of applying Nevada judgment, dollar signs, and whether or not we can sue, all that in type of immunity for public officials.
So the full faith and credit clause and the doctrine of interstate sovereign immunity represent two different aspects of protection that the framers enshrined in the Constitution. So the full,
That may be the case, but Hyatt, I read Hyatt back and forth, up and down.
Of course,
till
Your
my
Honor.
eyes glazed over. And Hyatt said very clearly, and there was no bones about it, if you don't have explicit consent from a state, you can't sue that state in another state. That's it. That's all it said.
Yes, that's true. And of course, unless there's an affirmative invocation, which
Right.
Your Honor found in
Here's the
Belfast.
problem with Hyatt that Belfan that we decided was that the other side of the equation was never discussed for some reason. It was they bandied about it, but they never addressed it, and that was under Lapidus, the U.S. Supreme Court case about how it could be a tactical advantage for someone to wait this long and then use sovereign immunity as a defense.
Yeah, so with respect to Lapidus, which obviously concerns the doctrine of a waiver of sovereign immunity by affirmative invocation,
Right.
it's true that, as Your Honor held in his decision in Belfan, that the passage of time alone can be a factor. However, as the cases that we cite in our reply, the cases that take perhaps the broadest reading of Lapidus, we cite the Ninth and Sixth Circuit cases, Blimeister, Hill, and Koo. There still needs to be an analysis of what exactly was the litigation conduct, how much weight does it have? So for example, in Johnson, the Ninth Circuit held that because the state had filed 2 dispositive motions and then raised the defense of the 11th Amendment, that it was waived. In the Blimeister case, the Ninth Circuit held that because the state had filed a motion for summary judgment and only raised the 11th Amendment defense when the district court indicated that it was most likely not going to grant the motion.
Counsel, weren't you about to start trial in this case? I mean, how can you distinguish this case from Belfon except that the trial had already taken place and you were about to begin the trial? How could that not be a waiver under those circumstances?
Because it's the weight of the litigation so I guess to put it most simply, it's the quality of the litigation conduct, not the quantity alone. So that's
Well, then
why-
maybe it's a factual issue for the jury to decide that, right?
I'm sorry, Your Honor, say
Maybe
again?
it's a factual issue for the jury to decide whether or not what you've
No.
done it can't be done as a matter of law, but then it may be a trial of fact question.
Well,
Right?
Justice Breyer makes clear in the Lapidus decision that a question of waiver is certainly a question of federal law. The Supreme Court held that in doing away with the authorization requirement that was originally relied upon by the Ninth Circuit in that case in the Ford decision of the Supreme Court in 1945. But essentially our main argument is that what matters the most is what exactly the litigation conduct is. And,
You know,
and the
what
Ninth-
really bothers me and concerns me is that this whole concept of sovereign immunity is nothing new. This has been in existence from the beginning of time, way back when the 11th Amendment was enacted, right? So that the Hall decision gave you guys a sovereign immunity. I mean, Hall basically said at that time was that it was the foreign state that had to decide on the full faith and credit whether or not to haul that foreign state into our court, right? So it was always there, but you never asserted it in your answer, though.
If I could just address that, Your
I'll
Honor.
allow you to answer.
We argue, obviously, that there is a fundamental distinction between a comity defense, a full faith and credit clause defense, and a true interstate sovereign immunity defense. A comity defense assumes jurisdiction as an axiom, whereas a sovereign immunity defense does not. And the closest analogy that I could come up with would be it's kind of like, to use an analogy, personal jurisdiction versus forum nonconvenience. One assumes jurisdiction, the other doesn't. And so that's our argument.
I'm not assuming anything. I'm not confusing anything. I'm just saying you had the sovereign immunity defense in existence when you filed this, when you served the answer in this case.
Well,
That's plain and simple.
Well,
And you can respond to that on your rebuttal time.
absolutely, Your Honor. Thank you.
Counsel, I'll hear from you now.
Good afternoon, Your Honors. Lawrence Lame for Jonah Grossman on behalf of the plaintiff respondent. I really don't have much to say after this, but in any event, this is a 2013 case. 8 years old. Belfan was from 2012. Henry was from 2015. As you indicated, the defense of sovereign immunity was available from at least Hall, not asserted at any point by the defendant. There is no defense whatsoever, sovereign immunity indicated any time during this period, the 8 years until just before, obviously, they made their application.
What Hyatt did was Hyatt made it easier to win on a sovereign immunity defense. That's what
Yes.
Hyatt did, but it never created the immunity defense.
No, absolutely not. This was actually, in my view, well before Hall, available as a possible defense. I also think, and again, I do not disagree with the idea that Hyatt 3 basically did not, as a part of the actual decision, talk about waiver. I read it as indicating that, at least in dicta, that they're acknowledging waiver as a valid ground. That's how I read it. But in any event, what the defendant is seeking here is the right to have an intra-litigation forum shopping, to just watch the case develop throughout, and at any point, up to the trial, according now to is the huge moment of truth, decide we're not happy with how this is going, so let's just get out of it. It may have taken 5 years, 6 years, 8 years, but who cares? Who cares about the expense, the inconvenience, the time that the court took? First of all, the note of issue in this case was filed initially May 2nd, 2016. There was a second note of issue filed May 13th, 2019. The case would have been tried long ago had not it been for the COVID interruption and also obviously the application to dismiss. So and by the way, Belfand explicitly says the question before the court is whether or not we have to dismiss a trial-ready case. Not a case in which there's already been a trial, but a trial-ready case. That's the language of the court. This is a trial-ready case. It's been a trial-ready case for years. As a matter of fact, there's a conference in the Supreme Court, excuse me, I believe it was October 7th, to discuss what happened in the appellate division and to schedule a trial. The discovery has been extraordinary in the case, including a deposition in California that we were forced to undertake. There's been vigorous participation throughout. There was no indication at any time of any assertion of sovereign immunity or any reservation in terms of holding back and defending the case fully. There's simply no basis to hold here that under the circumstances, there has not been a waiver. It could not be more explicit given the conduct. Thank you.
Thank you.
Thank you, Your Honor. Our litigation conduct here is obviously nothing like the litigation conduct in Belfand and Henry, and obviously, as Justices...
Counsel, isn't the only difference that the trial already took place in those cases and the trial's about to take place in this case? What else is the difference?
That is the main difference. But
What other difference is there?
Okay, so why that's significant is because we have not filed any dispositive motions. We are not seeking...
Sovereign immunity, the waiver only applies if the trial has already taken place. That's the only circumstance in which a waiver should be found to have taken place?
No, I'm not saying that. What I'm saying is the litigation conduct here is not on par with the litigation conduct in Belfand and Henry. And the court said at page 7 of its opinion in Belfand, the question of waiver is necessarily factual in nature, which means logically then that it varies from case to case. So the litigation conduct here is nothing like Belfand and Henry, and we know...
Counsel, I need you to bring your mask over your nose because the next person who stands at that mic will have your droplets on the mic head.
My apologies, Your Honor. Sorry. So we know from Lapides that it's not just the passage of time, it's the actual litigation conduct. The litigation conduct here is participation in discovery. There were 4 motions that were filed in this case.
You're going to...
Counsel, how many years passed and how much litigation activity went on in all those years? EBTs, conferences, court agenda conferences,
Of course.
et cetera?
Of course, Your Honor, but of course,
And that's nothing.
well, no, it's not that it's nothing. The litigation conduct needs to be sufficient to rise to the level of an affirmative invocation, because under
And
the
my colleague has asked you, I've asked you, he's asked you, what is lacking? What was lacking in the litigation conduct here that you should be put to a separate rule other than what happened in Belfan?
What's lacking is that Lapides requires a focus on the actual conduct, not just the passage of time. In Belfand, we conceded liability, proceeded to trial. In Henry, we tried the case to verdict. Here, all we've done is participate in discovery, and if you compare that with the cases at the Supreme Court itself.
Counsel, discovery is the bread and butter of our business.
Of course.
Without it, you don't get to trial. And here, you were on the eve of trial.
Of course, well, of course.
Which means everything was done, except, as my colleague has said 3 times, except the actual trial. That's it.
Of course, our position was that there was no sovereign immunity defense available until.
Oh, that's not accurate. Don't say that, because there was sovereign immunity under Hall, which was in 1970. You just didn't assert it. And just by coincidence or chance and lucky chance, Hyatt came down. Because you guys, New Jersey Transit could have been Hyatt. Instead of Hyatt, you guys could have taken it all the way up to the U.S. Supreme Court, right? I mean,
And with that said, thank
But as a
you.
matter
Your
of stare
time is up.
decisis. Thank you, Your Honor.
Okay, Gould versus Jewish National Fund. You may proceed.
Good afternoon. May it please the court. I'm Tony Harwood, counsel for petitioner Bruce Gould. The undisputed facts prove that Bruce Gould was elected president-elect to serve a term as president after the conclusion of the term of the current president, Saul Lieberman.
Even if everything you're saying is true, and that we assume for purposes of the argument that his election as president-elect entitled him to become president at the end of that term, that was in 2019, and the president stayed on for another 2 years. So when the time came for that president to step down, he was no longer president-elect. So how could that argument stand in light of those circumstances, even if we assume that being president-elect entitles you to be president?
The record shows, the respondents' admissions show, this is the CEO, the then president, the chairman of the nominating committee, and the chairman of the board, all said that Mr. Gould would succeed Dr. Lieberman after he served 1 or 2 terms at his option. There's a speech in the record that the chief of staff for the CEO drafted for Mr. Gould to give, which said—
But counsel, he wasn't president-elect at the time the president stepped down. He was no longer in office at that time.
the time is October 1, 2021. That's what the record shows, 1 or 2 terms. The second term is up October 1, 2021.
Right, but he wasn't president-elect anymore at that time.
He's president-elect. By definition, president-elect is the person elected president whose term has not yet begun. And he was elected president for a term to begin after Dr. Lieberman served 1 or 2 terms. The second term is up. He's president-elect until that second term is up. He was improperly removed in violation of the not-for-profit law from the position of president-elect. Legally, he continues to be president-elect today.
Sir, who removed him?
The respondents removed him. And it was not the board of directors, and it was not the board of trustees. And the not-for-profit corporation law is clear. If an officer is to be removed with cause or without cause, the removal must be by the board of directors or the board of trustees.
Do the bylaws of this organization recognize a president-elect position?
The bylaws recognize a president position. They don't
Counsel, I'm going to ask
specifically—
you, counsel.
Yes.
I know you heard me.
Yes,
So please answer the question I asked,
yes, I'm trying.
which was, does the bylaws have within it a president-elect position?
No, it does
No.
not.
Okay.
However,
And the bylaws have never been amended according to the not-for-profit law, as they must be, to so reflect a president-elect position. Am I correct?
you're partly correct. You're correct that they have never been amended. However, where I disagree with you is that the term president-elect has a clear, universally accepted meaning.
So now you are suggesting that the court should decide cases based on what is universally accepted rather than the governing documents of an organization?
It's not me who's suggesting it, Your Honor. It's what the case law stands for. It
The
says,
case law says that we can ignore the bylaws of an organization and not adhere to their governing documents?
no, the case law says that when interpreting bylaws, words should be given their common, ordinary meaning.
And again, I say to you, did the bylaws have a president-elect position? You said no.
Correct.
So how can I interpret something that doesn't exist?
I can answer that question for you. The bylaws have a position, president, okay? When Mr. Gould was elected president-elect, by definition, that means he was elected president for a term to start in the future.
When you say by definition, whose definition?
The definition is undisputed. It's in the dictionary. It's
not in the bylaws.
There's no definition in the bylaws. That's correct. And so the bylaws do not countermand the ordinary meaning in the dictionary.
Thank you.
That's what
You'll
the
have
case
time
law
on
says.
rebuttal. Counsel, I'll hear from you.
Your Honors, Bradley Mitchell for respondents. Rather than to repeat the questions actually Your Honors have already asked, you have stressed the point about the absence of the definition in the bylaws of President-elect, that the bylaws are very specific with regard to who the officers are. The only comment that is just flatly wrong that I want to comment on is that Mr. Gould was removed from the President-elect position. He simply was never removed. He served the full 2-year term. The bylaws, again, which are the governing documents, state that these honorary positions are for 2 years. He served for 2 years. 2019 came. Critically, he took no steps at that time that were all available to him to raise the objections he has raised in this lawsuit. In fact, he sat on his hands. In fact, he let himself be elected to another position, which for the last 2 years, as a matter of fact, he has done nothing. Yet he comes to this court and asks you to install him as president. The judge below said in a very straightforward way that the 2011 bylaws that govern this case do not guarantee or offer any protection or procedural requirements for the honorary officer title of president-elect. Mr. Gould's rights were never infringed upon by my clients. He served his full term. He didn't take advantage of opportunities had in 2019. The judge below properly dismissed the case for those reasons. I'm happy to answer any further questions you honors have.
Sir, did the respondents hinder or prevent the petitioner from running anew or running again for president-elect when his initial term of president-elect expired?
Absolutely not. He could have taken advantage of the procedures that existed in the bylaws to get on the slate of nominees. He did not do that. He has raised a somewhat preposterous argument that because the notice did not include the addresses and was procedurally defective, the election doesn't exist, and therefore he is now president.
Well, let's assume that that election was invalid. What would follow from that?
Well, it should not be invalid, first of all. The case law
But
is
assuming,
fairly,
humor me, assuming it was
assuming it was invalid, then your honors have great latitude as to crafting the remedy. I do not think it was invalid, plainly, but if it were, the proper remedy was have another election, truthfully. But the case law is clear. The court should not interfere with a properly held election, except if there was instances of fraud, complete lack of notice, a great disservice that occurred in the conduct of that election.
So you're saying that in 2019, when he would have, based on the 2017 election, been president-elect. There was another election,
There was an election in 2019.
and the 2017 to 2019 president ran again to be president.
Yes, he did.
And did anyone run for the president-elect?
No, because no one, the nominating committee did not renominate anyone for that position. It was in point of fact, for 2 years, president-elect existed in this organization, the 2 years at issue. It never existed before, and it hasn't existed since. It doesn't exist in the bylaws. It did exist for 2 years as an honorary position. That's plain, but has not existed after or since.
Does the bylaws have any provision with regard to honorary positions?
Oh, yes. The bylaws clearly set forth that the nominating committee can create honorary positions to assist in the organization, and that they sit for 2 years, and that at the end of 2 years, this is a 2-year election cycle at JNF, there will be a new slate. There may be the same honorary positions, there may be new ones, but they're honorary, and only the national officers are defined, and there are 15 defined ones in the bylaws, and president-elect is not one.
Thank you. Counsel, you have 1 minute on rebuttal.
First, it's not correct that the respondents did nothing to interfere. The fact is, and it's clear in the record, the notice that was sent out of the 2019 election did not contain the addresses of the Board of Trustees. The bylaws.
But how did that prevent him from seeking to either become president that year or to have the nominating committee nominate him once again as president-elect? How does the absence of addresses prevent those two things from happening?
Yes, Your Honor. The bylaws specifically state that the addresses are supposed to be included so that someone can petition the board to participate as a candidate. Without the addresses, he was unable to petition the board. He had no way to contact them. It says that you can gather 25 signatures from the board members, and he had no ability to do that because he didn't have their addresses. The final thing I would like to say about this.
Counsel, you have 30 seconds because you're out of time already.
Thank you. The final thing I would like to say about this is that it's clear from the record that every single respondent stated publicly and to Mr. Gould that he was to succeed Dr. Lieserbrand. If he is going to be denied that opportunity because of a technical reading of the bylaws, which I say is incorrect, but that's for you to decide, then they made misrepresentations. They made false representations to him and to everybody they solicited donations from, that Mr. Gould was the president.
Thank you.
He has claims for false representation.
Thank you.
And fraud.
Jones versus O'Neill. You may proceed.
Good afternoon. May it please the court. My name is Renee Myatt, and I represent Fred Jones. Mr. Jones is a 45-year-old African-American male. He was a police officer with a stellar record. There were no disciplinary problems.
Counsel, putting all that aside, why isn't this application untimely on the ground that it was made more than 4 months after the determination, which was the date he retired?
Your Honor, the reason it is not untimely is that my client received a letter in May of 2019 from the department indicating that they were not going to allow him to be, for lack of a better term, rehired for 1 day or reinstated for 1 day to allow him to get the good guy letter.
Let me ask you, counsel, is there any formal procedure to request reconsideration of a determination such as that?
Your Honor, that's an excellent question. There is nothing that I saw in the record or the patrol guide or the policeman's guide that indicated there was an opportunity to do exactly what Your Honor is asking.
And did they ever tell him, we are going to consider on the merits your request for consideration, and we'll get back to you with an answer?
No, Your Honor, they never did that.
Then why should the statute of limitations run again or run anew?
It's not running anew. The kind of the crux of my argument is that when my client receives this letter, the May 2019 letter, that is when he is aggrieved. That's when the statute of limitations should run.
He was aggrieved when he retired and received the card saying that he could not carry a firearm. He knew then that there was a determination.
Well, Your Honor, and I know that's the argument that counsel for the city represents, but with respect to my argument, at the point that he receives his no firearms card, what happened at that point, and Your Honor, I'm sure you've read my papers, that at that particular point, the allegations against him, and you know what I'm referring to, were unfounded. And the police department, they also knew it was unfounded. And so that's why—
Counsel, didn't he know at the time he retired that NYPD was investigating this, that they had not yet completed their investigation, and they had not yet made their own determination, that he voluntarily elected to retire despite the fact that he was still on modified status and no determination had yet been made by the NYPD?
Actually, what happened, Your Honor, on May 2nd is when my client is placed on modified duty. And he's supposed to retire on May 31st, again, May 31st, 2018.
Did anything prevent him from pulling his retirement papers and waiting for the determination so that he would no longer be on modified status at the time of his retirement?
Excellent question. He had no room. There was no room. That's the point. He was allowed, he was designated to retire May 9th, 2018.
But my question was, could he pull his retirement papers? In other words, could he reach out to, which I'm assuming the police department has an HR division, could he reach out to HR or to the retirement unit and say, look, I have this pending situation. I thought it would be resolved by now. I'm going to have to push back my retirement another couple of months while I wait for this determination.
He did not have that opportunity, and that's what the issue is. He did not. He was required to retire May 31st, 2018. And the reason I say that is because when he gets the unfounded letter on May 22, 2018 from the Office of Children and Family Services, I see my time is up.
Go ahead, continue.
Thank you. When he gets that letter, he recognizes still when I say there's no room for him to go back and say, you know what, let's pull my application because I need to wait. He does not have that opportunity. So he's forced to retire. It's not like he's running.
When you say, you keep using the word opportunity.
Okay.
And what I want to know is, when you use that word, are you saying the NYPD would prohibit him from pulling his retirement?
As far as I know, they would, because they pressed him to retire May 31st, 2018. I don't have anything in the record that says otherwise, but they indicated to him that he had to retire on that date.
All right, I'll hear you on rebuttal.
Thank you.
Good afternoon, Your Honors, and may it please the court. Amy McCampbell on behalf of respondents.
Could you answer that question? Did this officer have the ability, without approval from NYPD, to pull his retirement date in light of this open situation?
Sure, Your Officer. Sure, Your Honor. There's two things that the officer could have done here. First, under the patrol guide, he could have requested to his department advocate that his status be examined. That's on page 55 of the record, an excerpt from the patrol guide.
Yeah, but come on, please. We have a subpoena requests from the NYPD that take 8 and 9 months. So please look at my file in 7 days and get me a turnaround determination is not exactly something I would expect would happen on time. So really, did this man have a chance to say, there's not enough time between your determination of unfounded and my ability to apply and get a status change before my retirement? Could he, by himself, say, I need to change my retirement date?
Your Honor, my understanding is there are administrative steps he could have taken to delay his retirement date in order to allow this investigation to proceed. Mr. Jones took no efforts to do so. And case law recognizes that when officers retire, knowing that they are on restricted or modified duty without firearm privileges, then that is what is controlling at the date of retirement. The Giraldes versus Bratton case, the officer had an open investigation. He retired. This court recognized that the NYPD's determination to deny him the good guy letter.
Well, here the investigation was no longer open. It was found unfounded. And it would seem to me that unless there's something this court doesn't know, that had he not been in the chain for retirement, his status would have been returned to normal.
Well, Your Honor, there were two investigations here. There was the investigation from the local social services district in Westchester. That one had concluded. However, the NYPD had its own internal investigation, and that had not concluded at the date of his retirement. It was still open. Nevertheless, the petitioner proceeded with his retirement. He took no steps to try to delay his retirement or to try to ask NYPD to re-examine his status, and for that reason, his status at the date of retirement is controlling.
Are you saying that if he had requested officially a review of his status before the retirement date, that request would have given him a window to post-retirement be able to get the good guy letter?
Your Honor, it is the status at the time of retirement that is controlling, but again, there were steps he could have taken. He could have requested a review. He could have attempted to delay his retirement date, and here the officer did neither. And the cases from this court recognize that when an officer takes no steps prior to their retirement to
So he was not, the opportunities were, what I'm gathering is that the opportunities were there, but this record does not demonstrate that he took any steps to do anything.
Exactly, Your Honor. And in that respect, this is just like the Coslow case and the Giraldes versus Bratton case, in which this court has affirmed the denial of good guy letters to officers.
I would gather you would have a harder argument if he had taken steps and you hadn't acted on them, then you would be behind, you would be having a hard time defending that.
It would be a different case, Your Honor, but that's not the case here.
Okay.
And the second reason, aside from the time-barred reason why the petition was rightly dismissed here, Your Honors, is because a petitioner fails to state a cause of action. NYPD's policy was not arbitrary and capricious, and it was applied rationally. Thank you, Your Honors.
Thank you. Okay. Counsel, you have rebuttal time?
If Your Honors don't have any further questions.
I actually have a question for you.
Thank you.
Assuming that you were correct that there was no way he could have delayed his retirement, what prevented him from actually bringing this challenge to the lack of the letter within 4 months of his retirement, which at least would have obviated any argument that it was untimely and could have been determined on the merits in the context of an Article 78 proceeding?
But I guess, Your Honor, that's kind of the basis of my argument. And at the time that he retires and gets the card that says no firearms, at that point, he's not thinking that, okay, you know what, I have to do something to...
Why shouldn't the statute, because he could have brought an Article 78 at any point after he got that letter, why shouldn't that be the determinative date for the statute of limitations?
Because at that point, again, with all due respect, at that point, he's not aggrieved at that point, at least.
He is aggrieved. He didn't get his letter. He didn't get the status he wanted. He didn't get his good guy letter.
I understand. I understand what Your Honor is saying. At that point that he retires, Your Honor is saying that he is aggrieved. I am saying that that is, and I see my time is up, but my point is that he is not aggrieved at that point. He is aggrieved later on in May of 2019.
Thank you.
Thank you very much, Your Honor.
Counsel for Brembo versus TAW Performance. You may proceed.
Good afternoon, Your Honors. May it please the Court, my name is Robert Spolzino, and I represent the appellant TAW Performance. Summary judgment should never have been granted here. The lower court granted summary judgment only by turning the standard burden on its head. 9 times in its decision, the Supreme Court said TAW didn't prove or TAW presented no evidence. That wasn't the standard. TAW is the non-moving party. Therefore, it had no burden until the appellant established its entitlement to judgment as a matter of law.
Why didn't they establish their burden by showing that there was an agreement and that they complied with the agreement by not selling the goods to anyone else in the exclusive territory? Why wasn't that enough to establish their prima facie burden?
Because they didn't defeat the defenses or counterclaims of breach. The only evidentiary material here.
Wouldn't the burden then shift to you to show what the breach was, which then they had the ability to refute?
My understanding of the burden, Your Honor, is that on summary judgment, the moving party has to establish that there was no breach, that it did not breach the contract.
Okay, so what disputed evidence is there of a breach of the agreement by them?
Well, the only evidence they submitted, Brembo submitted in support of its motion, was that on one occasion, Brembo assisted in a complaint under the Vero program to eBay. Thereafter, Brembo refused to participate in that.
But wasn't that because eBay communicated that they did not believe that this was an appropriate complaint?
But
Am I correct about that?
the eBay asked questions about what was presented. And there were questions. In fact, if it's necessary to go to whether there are questions of fact, and I would submit that it's not, because there are other provisions of this contract that are relevant and that Brembo had to show that it did not breach. But even if that's necessary, there was a tribal issue of fact on that. There's a real question here about whether the products that were being shipped in, doesn't seem to be any real dispute that products were being shipped into this country by Italian distributors who were getting their products through Brembo's chain from Motor Quality. Motor Quality was distributor for Omni and Carpimoto. Motor Quality was owned by the chairman of Brembo.
And how is that a breach of the agreement between these two parties? Assuming what you're saying is true, and I think it is true, how does that breach the agreement between these two parties?
Well, aside from the specific obligations with regard to the Vero program and so forth, how is that sale a breach, Your Honor? Because this is an exclusive distribution agreement. The agreement was, and it specifically provides in section 7.6, that supplier, Brembo, shall supply the Brembo products only to distributor for resale in the territory.
And how was that breached?
Because Brembo...
They didn't sell to anyone else in the
They didn't sell, no.
The person they sold it to
They were sold...
didn't sell it to anyone in the territory. It was the next person company down the line.
But they sold to Motor Quality, knowing that Motor Quality was selling to Omni and Carpimoto, and that Carpimoto and Omni were selling in the United States.
So you're saying they shouldn't have sold to Motor Quality because Motor Quality was then selling it into a market they shouldn't?
I'm saying they breached the contract by doing
Counsel, I'm giving you a very specific question, right?
Yes.
So is that the way you see that the breach is happening? I'm trying to understand exactly what it is you say they did wrong.
That's one of the ways. Okay, that was section 7.6, and it's the implied covenant of good faith. Can't make, if an exclusive distribution agreement means something, the company that's the
under this
supplier-
agreement, Brembo could sell their product to various distributors, but they had an exclusive with your client with regard to the North American market, correct?
That's correct. Correct.
But there were other distributors to whom they sold that sold internationally.
Correct.
Correct? And there was no exclusive arrangement with regard to the international markets, correct?
Well, we don't know that. That's not in the record.
Well, your client didn't have one.
Correct.
Correct. So that if a distributor that was properly sold Brembo products then sells to others, you're saying Brembo is responsible for that?
I'm saying, at least on these facts, 2 points. First of all, there's a question of fact there as to what Brembo's obligation was and what its duties were.
Well, no, it's not a question of fact. The contract tells you what their obligations are, no?
The contract says they cannot sell, I'll read it to you, Judge.
No,
cannot
I've
supply
read it, and
only
what
to-
I just summarized to you is accurate, right?
Well-
So they can sell to other distributors so long as those distributors are not for the North American market.
They can, well, it says they can only sell to distributor for resale in the territory. And what they did
How
here
did
was,
they breach that specific language? What did they do within their actions to breach that very specific unambiguous language?
they sold to Motor Quality.
Right, but where in the agreement are they prohibited from selling to Motor Quality outside of the territory?
They're not, except, Your Honor, for the fact that they knew from the beginning that Motor Quality, which was owned by their chairman, was selling these products to Omdia and Carpimoto, which were selling into the United States. So what they can't do is circumvent their own agreement. That's what they did here.
Okay.
They circumvented their own agreement.
You'll have time on rebuttal.
Thank you.
Good afternoon, Your Honors. Miriam Skolnick from Hertzfeld and Rubin on behalf of Brembo.
Why is he not right that your client was essentially wearing two hats and undermining the exclusive arrangement he had with TAW?
Well, I'm not sure how he feels that we were because Brembo was selling to Motor Quality. Motor Quality was not selling into the United States. That's not a claim here. There's no allegation. I just want to correct the record. My adversary keeps saying that Brembo's chairman owned Motor Quality. There's nothing in the record to support that. At best, there's a statement, a question asked, did he own 20% at some point? 20% is not controlling by any method. Counsel changes that 20% to 40%. The 40% is unfounded, but even if it were, it's still a minority. So that's just a red herring. I just want to get it out of the way. But Motor Quality here was selling it to a third party. They were selling it to retail salesmen or suppliers.
Outside of the U.S. territory?
Outside of the U.S. territory.
Okay.
There's no way that any manufacturer can sell a product and then it can be sold, they can enter into contractual terms with their immediate distributor. But once it leaves that distributor's hands and the distributor hasn't breached the contract, the next party can't be stopped from doing, if it belongs to them, then they can sell it. And they can sell it on eBay, they can sell it anywhere.
Well, the next party can do what it chooses to do, but that doesn't mean under a contract based on, agreements that you've entered into that you don't bear some responsibility or liability, as the case may be. Again, depending on the language of the exclusivity agreement.
Right. So here the agreement was that Brembo would not sell to anybody but TAW for distribution in the United States. There's no allegation here that Brembo did that. Brembo sold to Motor Quality for distribution in Europe. Motor Quality distributed in Europe to various other companies. Those companies sold the product. And in fact, all of the plaintiffs, Mr. Martin, Mr. Gordon, and Mr. Rogers, all admitted on the record that there is nothing that any manufacturer can do to stop a third party from selling products that they have bought.
Was there any evidence, and the two companies at issue who began selling in the U.S. market through eBay was Carpimoto and Omnia, correct?
Right.
Is there any evidence in the record that your client, Brembo, the CEO, et cetera, has any ownership interest in Carpimoto or Omnia?
None, Your Honor.
Okay.
Or any contractual relationship. Unless the court has any other questions, I would just note in terms of the burden of proof that Brembo met its burden because this case has always been about the sale of genuine product on eBay. We showed that we complied with our obligations in that regard. The issue of whether these were counterfeit products or for whatever other reason, violated a trademark or a copyright infringement was not raised in the counterclaim. It was not raised anywhere until the opposition to summary judgment. So the court correctly placed the burden on TAW.
Well, you have the affirmative burden as the movement, right? In the first instance, to make an affirmative showing of entitlement to judgment in a matter of law. So as
which
part
we
of
did.
here, it would be, part of that I suspect is you've got to show that you didn't breach. You're in the right. And
Yes.
so what evidence in admissible form did you adduce before the motion court to establish prima facie that you did not breach the exclusivity clauses?
The evidence that we showed, that we didn't breach was the fact that these were genuine products, the fact that we sent the letter to eBay that they asked for originally, the fact that eBay doesn't allow you to use their program, which in fact we had told plaintiffs in advance, TAW in advance, that they could not use this Vero program or any other program to stop the sale of genuine products, and that all the requests that were made that were reasonable, which is all that the contract requires, we abided by them and fulfilled our obligations. That shifted the burden to TAW to show that there was an actual breach. And instead, they came forward with a brand new claim that had never been raised before in the counterclaim or in the testimony.
What about the argument that putting aside, or not putting aside, we can't put it aside, but taking the language as it stands under 7.4, applying the doctrine of good faith and fair dealing,
Yes.
why isn't there a tribal issue of fact in light of that doctrine as to whether the exclusivity provision was breached?
Unlike all the other cases where the duty of good faith and fair dealing has been applied, usually there's an affirmative step taken by the defendant to somehow interfere with the ability of the plaintiff, or in this case TAW, to get the benefits of the contract. Here, no such assertion has been made. And the only claim that keeps being made is that we had to take commercially reasonable steps, but none of them have been identified. The only quote-unquote commercially reasonable steps were all either illegal or would have put us into a breach of contract. So other than the steps that we did take, and we did work very hard to try and accommodate with the euro exchange rate and other issues, there was nothing else that we could have done that would have...
Your client also offered to provide a U.S. logo.
Yes, we did.
For TAW so that their products could be distinguished on the market as being appropriately sold in the U.S., correct?
Correct.
And they declined that offer?
Yes.
Okay.
Thank you. Unless the court has questions.
Counsel, you have 2 minutes on rebuttal.
Thank you, Your Honor. Just briefly on that point, giving my client a different logo was not a protection of their the intellectual property rights that they owned as a result of the exclusive contract. They were entitled to Brembo's logo, not something different. As far as the gray market...
As I understand it, they were going to create a special logo that would allow the market to understand that this was the only authorized seller of Brembo products. Am I mistaken about that?
Yeah, only in that they were going to create a separate logo. My client had a contract that allowed him to use Brembo's logo. That was what's critical to their success in the market. It was using Brembo's logo, not some other logo that Brembo would create for them. Just to get back to the issue of whether the gray market goods issue was raised, it was raised by TAW. It's at record 1308. The other issues that go to summary judgment here, which established that summary judgment should never have been granted, is that there was an obligation under the contract, section 5.3, and we raised this in our brief, to enforce the MAP policy, which there's nothing in the moving papers that says Brembo enforced the MAP policy, and the opposition papers established that they didn't enforce the MAP policy. The 5.4, with regard to the material difference, there's at least a question of fact as to whether the different warranties for the products that TAW was legitimately selling and Carpimoto and Omnia were not legitimately selling in the U.S. was a material difference that would have required or would have allowed TAW to pursue them under the Vero, pursue excluding those products under the Vero program, and would have required Brembo to participate in that effort under Section 5.4. So in addition to that and the covenant of good faith, there are real questions of fact here. Summary judgment should never have been granted. Thank you, Your Honors.
No, I'm sorry, you cannot speak after argument. Matthew versus Lene. You have 3 minutes, counsel.
Good afternoon, Your Honors. May it please the court, Douglas Kapanis for Matthew P., the petitioner appellant, who respectfully requests this court to reverse 2 orders issued by the Family Court in New York County on May 28, 2020. The first vacated a temporary order of protection in place against Linnea W., the respondent, on both his behalf and on the party's daughter's behalf. And the additional order that was issued on that date granting Linnea W., the respondent, unsupervised parenting time.
Counsel, just to clarify something, why are you referring it as a vacating? Wasn't the issue that it was already expired by its terms on the date everyone appeared in court and she just refused to extend it rather than that she vacated it? Because by its terms and by the administrative order that was in place, wasn't it expiring then anyway?
No, because the order of during the pandemic extended all orders until a hearing.
Right, so that was the date of the appearance. So why on that date wouldn't it have expired based on the appearance before the court?
Yes, but Your Honor, on that date, my client had no notice of what was happening. The only reason we found out about that date is because I had been keeping track of the court dates on e-courts. We were never served with the custody petition and never served with the order to show cause. And the court even acknowledged on that date that we were not properly served with the order to show cause.
But I'm not sure if you understand my question, though. Assuming that's all true,
Yes.
why isn't still the issue about whether or not it should have been extended because it vacated based on your being in the courtroom?
Yeah, well, it should have been extended based upon circumstances that happened between its issuance and the date of that May 28th appearance, which was the respondent being arrested for endangering the welfare of a child with the party's child, having at least one Child Protective Services indicating finding against her, and concealing both of those in her filings with the court. So the propriety of the court's temporary order of protection in initially being granted was borne out by the respondent's actions. She had threatened to abandon the party's daughter at my client's apartment building, knowing he was not at home. She actually did abandon the party's daughter, leaving her at home while she went out to the store for upwards of an hour and was arrested. And I believe that case is still going on. She currently now has supervised visitation, as stated in the brief, due to a stipulation. But a CPS report indicated and being arrested for endangering the welfare of a child surely warrants that TOP be continued.
Did the court, I know that there was concern about the mother's threats of taking the child, leaving the country and taking the child with her to Italy, I believe. Is that correct?
Yes, Your Honor. There were 2 threats.
Was her passport turned into the court?
No, it was not until Justice Kapnick of this court, during the emergency stay application, that those passports were turned over. There was no provision for that in the family court.
Okay, and they have been turned over?
They have been turned over, and I still have them in a safe deposit box.
Okay.
Pending what, sir?
Pending further order from the court on what to do with them.
Okay.
And So currently, there's been no visitation.
No, as I stated in our opening brief, there was a so-ordered stipulation entered on June 16th by the parties in the family court, which provides her with 6 overnights supervised, and then my client, who is the temporary custodial parent, has 8 nights unsupervised.
So when you say supervised, what does that mean?
We're doing virtual supervision because it was the pandemic, so a list of supervisors are checking in by video with her and the child 4 times a day and keeping a logbook to make sure the child is okay, it hasn't been left.
And so what you are suggesting is that the custodial arrangement remain that way?
Yes, at least through the trial. We start trial in a week and a half on all issues in the family court.
Okay. Any other questions? Thank you.
Thank you, Your Honors.
All right. Empery Asset Master versus AIT Therapeutics.
Good afternoon, Your Honors. Kim Conroy, Caswood Spence and Torres, on behalf of Appellant Defendant AIT. We're here regarding the trial court's decision on a motion for summary judgment. These are 3 claims, very straightforward in their legal nature. One is a breach of contract for Section 3B of a warrant. Now, I would posit that Judge Cohen reached a correct conclusion in his analysis that during the oral argument. He specifically said, and I quote, pardon me, and I quote, "So if I dropped down from Mars and looked at your contract and it said something about, quote, the preceding sentence, close quote, I wouldn't need to go to the parole evidence just on the face of the document to figure out what that means. The only thing you have, it seems to me, is a question of whether, notwithstanding the plain language, there is a narrow theory to say, quote, well, the words don't reflect what we actually agreed, close quote."
Let me jump in, because that quote goes to the question, which is we've already seen this case before at the First Department on the motion to dismiss, and now we have the summary judgment. Since we already denied the motion to dismiss, which follows that we made a finding that it wasn't unambiguous on its face, so we would have granted the motion to dismiss, what's the difference now with your motion for summary judgment versus the prior motion to dismiss that should cause it to be a different result?
Sure. And I think Justin Cohen also addressed that as well. He said, here, I mean, just to put some cards out there, the word sentence is not ambiguous, and I don't think the First Department held otherwise. And when this came up before the First Department the first time, there was no, and even in the decision, there was no address with regards to whether or not the language was clear.
But if we denied the motion to dismiss, and I wasn't personally on that bench, but if we denied it, wasn't that a finding that there was ambiguity? Because if it had been unambiguous and the court had accepted your argument, wouldn't it have granted the motion?
Understood. My understanding, and I was here during that first time, was the court was saying, based on the pleading standard, based on what the complaint pled, there was enough pled with regard to sentences.
When you have a contract, it's no longer what the complaint says because you have the documentary evidence in front of you. So the court is obviously reading the documentary evidence, which is a contract, and making a determination based on the language of the contract.
Understood. Well, if you look at the language of the contract, and now after 2 years of discovery, I think the language on its face is quite clear. So that then turns, if there's an ambiguity here, there's certainly nothing in the record that supports that the language and the words as written in their plain meaning mean something different.
Except that it says as immediately, with regard to the immediately preceding sentence, and the immediately preceding sentence doesn't talk about the subject at hand.
I think we can look at that. I think it does, Your Honor, with all due respect.
No, it doesn't, with all due respect.
Fair enough. The third sentence says, upon each such adjustment of the exercise price, the exercise price is the new issuance price. The new issuance price is an adjusted exercise price. It's the same thing. And in fact, in the record, respondents' witnesses acknowledge that at their depositions, that they are the same. So saying upon each such adjustment of the exercise price, if you look at it numerically, the first sentence is talking about the exercise price. And in that first sentence says, and that could be the new issuance price, excuse me. The second sentence then goes, okay, and in the case of when there's a new issuance for no consideration, it goes to penny. And then the third says, okay, and in that situation, where you have that unique situation, where a company is trying to give away shares for free, this is when we're gonna agree and allow additional shares. And why is that? That's to keep people and companies from trying to give insiders, management, whatever, free money. And based on the record here and 2 years of discovery, there is no evidence or material disputed fact that appellant meant to limit this clause.
Isn't the whole purpose of this section in order to avoid devaluation of the investor's investment? Isn't that what this is about?
This is an anti-dilution provision.
Right.
Definitely. But there are different kinds of anti-dilutions. And
Yes, some that work and some that don't, right?
I would say there's some circumstances. There's price protection, and then there's share explosion. This clearly is providing price protection whenever the exercise price is less than stated in the original warrant. But it's not providing a windfall, and it wouldn't make sense. This is a startup company that's still making money. The idea that they were going to just say, okay, here you go. Every single time, if I have to make more money and I can't make as much, I'm going to now dilute the company. And like I said, Your Honor, I think the record is clear. There's not a material disputed fact here about what AIT intended. The witnesses for AIT both said price protection. It's also very clear that the respondent never spoke with the appellants. There's nothing in the record suggesting a prior agreement, which is necessary for Scrivener's error. But even putting that aside, going to mutual mistake, if you want to credit that that's what they wanted, fine. But I don't think there's a material disputed fact that my client didn't.
If we were to take the third sentence, the upon each such adjustment language, and apply it literally, what meaning or effect would it have?
I'm sorry?
If we were to take the upon each such adjustment sentence and apply it literally,
sure,
the way that you want us to give it its plain meaning, what meaning or effect would it have?
Well, I think you can't look at that phrase by itself because you have to look at it says pursuant to the immediately preceding sentence.
And as Justice Manzanet was discussing a moment ago, what does that immediately preceding sentence relate to?
I believe it relates to if any sale or issuance or deemed issuance is for no consideration, then the new issuance price, which is defined above as the adjusted exercise price, shall be deemed a penny.
So the second sentence is a deeming clause. If you have this type of issue or this type of sale, meaning one for no consideration,
correct,
then we are going to treat those in a certain way. We're going to deem them, if you will call it the deeming sentence. We'll deem it worth a penny. That is not an adjustment. That's a deeming. The adjustment occurs, I think, in the first sentence. The first sentence talks about we're going to, in certain situations, we'll have to adjust the exercise price. Right? It talks about the exercise price. If there are certain sales or transactions that are for a lesser value than the exercise price, then we're going to adjust the exercise price. So in the first sentence, it seems as though that's where the adjustment occurs. The second sentence is the deeming of certain types of stock to be worth a penny. And now the third sentence is talking about relating back to adjustment, which seems to relate back to sentence number 1.
May I answer?
Yes.
It's up to-
Thank you.
If you can
Well,
figure out
oh,
what I asked,
sorry.
sure, but
I'm sorry.
if you can figure out what I was asking, yes.
I think I
you
know what you're
followed.
asking. Thank you, Your Honor. I would respectfully disagree. I think that what the first one is, the first sentence is saying is the set exercise price, if it is adjusted, is deemed the new issuance price, right? It then, that exercise price turns to this new issuance price if it's a lower. But what happens then in those instances where you have an insider giving away free shares? And that's why the second one says, okay, and then in this instance, the new issuance price, where there's not a price to adjust the exercise price to, becomes a penny, right? And what the third sentence is then saying is that in those rare instances, we will provide as prohibitively, obviously, and as a preventive, we'll give you the benefit if the company steps out of line and tries to do something like that. So I actually do think, Your Honor, that both are talking about adjustments, two different kinds, obviously. And then that third sentence is specifically relating, and with all due respect, contract law is clear. If you're gonna try to read that separately, you're gonna have to excise the immediately preceding sentence, right? Now, to the extent that this is about reformation, like I was saying, oh, apologies, my time was up. I would simply say, on rebuttal, that I don't think that there's anything in the record that supports any material disputed fact on that issue. Thank you.
Thank you.
Thank you.
You may proceed.
Good afternoon. May it please the court, Karen Klein, on behalf of plaintiffs' respondents, Empery Funds. Now, appellant here says there's no disputed issue of fact. But if you look at the record on appeal, there's more than 2,500 pages, over 100 exhibits, including the majority of them put in by appellant themselves that show disputed issues of fact. I think the court hit
This paragraph here was subject to a lot of negotiations, from what I can remember from this record. A lot of emails are going back and forth about this paragraph, correct?
Yes.
Somebody forgot to read the last email, probably.
No, the last email is actually quite clear.
Well, I'm just saying that because it didn't get into the contract itself, right? That's where all this, we're arguing about, you guys are having this dispute about the language of this paragraph now.
We are, but
Somehow somebody didn't put the two together to clean it up. That's what I'm suggesting.
Someone forgot to clean up sentence to sentences.
Yeah, exactly.
That's our position, Your Honor. The last email, there was a lot of
the
back
decimal
and forth.
point, right?
There was a lot of back and forth between Deerfield, who is the lead investor who signed the same agreement and got the same form of warrants as Empery here, and AIT. Deerfield said, we want the full ratchet adjustment to be placed in. That's what they called it. They meant that when the price went down, the shares would adjust upward. That was their definition of full ratchet, and that's what they called it. AIT struck.
And the reason for that is so that the investor's investment is not diluted.
Yes.
Correct?
Yes,
That's
Your
the
Honor.
whole purpose of this section.
Correct, Your Honor. That's correct. Now,
To keep the company honest.
yes, Your Honor. Now, as AIT struck the sentence that provided for a share adjustment, and Deerfield responded and said, no, we want the full ratchet. That's important to us. That's our expectation. There's an email with AIT's CEO at the time saying, leave the full ratchet, keep it in. AIT's lawyers respond and say, we understand from the CEO, we're keeping the full ratchet in. We understand we're keeping all of their comments. And then what they did was they placed in the second sentence, the deeming sentence about the zero issuance considerations, and they stated in the cover email, this is AIT's counsel as well as AIT's placement agent, that they did that to clarify the irrational share issue, meaning that if there were a price of $0, there would be an infinite number of shares awarded, which just couldn't happen. So that sentence was placed in to clarify that issue. And the cover email explicitly said, these are the only changes being made. And this is why it was made. Now, weeks later, after this was negotiated, the draft of the agreements with the warrant was sent to Embry by AIT's placement agent with a term sheet which spelled out, in our view, AIT's understanding, again, of this language. And it said, when the price goes down, the shares go up. That was simultaneous with the disputed language, and that provided for Embry's agreement, and it provided for AIT's agreement. So I wanted to touch on one point with respect to the ambiguity. I think the court, the questions were very clear, and I think it's clear from the record that the court considered this before. Each such adjustment, the second sentence does not refer to adjustment. In addition, each such adjustment, there could only be one adjustment if we were to look at the second sentence as the one at issue, because once you go down to a penny, you're not going to go any lower. There's not going to be any more adjustments. So the each such adjustment language would not make any sense.
Well, couldn't it make sense if you had one no consideration transaction, and then later on had another one sentence? Could that be such adjustments, plural? There'd be multiple or successive?
No, Your Honor, because once the price is down to a penny, there's not going to be a further adjustment. You don't adjust again. The adjustment is based on the price, not the number of shares. So once the price is at the floor, there are no more adjustments.
But you couldn't have one for a penny to X, and then another one for a penny or for no consideration to Y, and then you have to make an adjustment from nothing to one to a penny?
You could have an adjustment, you could have multiple issuances for zero consideration or for a penny, but they wouldn't result in multiple adjustments of the share amount, because once it goes down to a penny, under the formula in the warrant, they're not going to adjust upwards anymore. It's at as high as it's going to get. I wanted to also just touch briefly, there was a lot of talk in appellant's reply papers here about the merger clause and the merger clause in the agreement. The case law is clear here. Merger clause doesn't bar a reformation claim. I'd cite the court to the Barash case by the New York Court of Appeals, 26 NY 2D 77. They also talk a lot about a claim of negligence. Again, Your Honor, it's very fact-specific, whether Embry missing one character in a long, complicated document, which everyone else also missed, was negligent. But even if it was, in a Scrivener's error case, negligence is not a bar. This is not an ordinary mistake case where it could be a bar. It's a Scrivener's error case. Now, with respect to the mootness point and the point of Section 3D of the warrants, I would just refer the court to the papers on those. I believe they're clear that there is no basis to claim that the warrants were mooted by exercise. When AIT failed to deliver the correct number of shares, we still have a right to a claim based on that. With respect to 3D, Section 3D of the warrants, AIT failed to make a proper price adjustment, as we set forth in detail in our papers. The 2018 capital raise, the structure of that, as we pled in our complaint and as this court upheld on a motion to dismiss, was a sham transaction. There was no, they called it one warrant, but it wasn't one warrant. They called it a common stock purchase warrant, but the elements, they had a quote-unquote tranche A warrant and a tranche B warrant. The tranche A warrant, there was no optionality. It had to be exercised on signing, and the payment had to be made. It was not actually an option. And the common stock purchase warrant, which is the packaging, again, there was no term, there was no exercise price. It did not have any of the hallmarks of an actual warrant. And for that reason, based on the extensive 2,500-page record, there are many questions of fact. The court properly denied summary judgment, proceeded to trial. That trial, there was a multi-day bench trial in April of this year, and the parties are awaiting decision. Thank you.
Thank you.
I believe Justice Owing, you mentioned that people just forgot, and I believe counsel said everyone missed it. But that's actually not supported in the record. Someone forgot. There is evidence that someone maybe
I got
forgot.
the emails though, right?
Excuse me?
I got the emails though, right? That's in the record.
Emails are in the record, but
Okay.
there are no emails supporting that AIT forgot anything relating to S. What is in the record and admitted by respondents' witnesses was that, yes, they literally said, we made a mistake. And they said in 2018, when they went back and read it, because they confronted my client and said, because of this 2018, I think this triggers Section 3B from 2016. And my client said, no, it doesn't. No, it doesn't. And that forced their client to go back and read the contract. This is all in the record. This is undisputed. That's their testimony. So there's no other witnesses. Deerfield did not testify that they missed an S. Did they testify they wanted more? 100%. Is it also clear in the drafting era, in the drafting back and forth, they asked for the full thing, and we said no at first, crossed it all out. Came back, and we said, okay, we'll give you a compromise. There's also in the record that Deerfield and AIT never spoke outside of those exchanges. So the idea of this extrapolation that there are all these people that agree with that is just not true. There were 30 plus other investors in between Deerfield and AIT. And what they're asking you to do is ignore all those people who read the contract, understood it on its face, and now somehow change the bargain that they bargained for. If this was AIT coming to them with this argument, on the flip side, if AIT came, say it said sentences, and AIT came and said, hey, there's investor A from back in the day that I agreed with, now I want to reform, that would be a laughable position. I would posit it's the same thing here. So with that said, I thank you for your time this afternoon.
Thank you. Adika versus New York City Transit Authority.
Upon each such adjustment of the exercise price.
You may proceed.
May it please the court, good afternoon, Your Honors. Christopher Della Carpini for the appellant, Miss Adika. If a witness on the stand knowingly misrepresented, denied the contents of an exhibit, the way Transit's counsel did throughout this trial, we'd call it perjury. As it was, counsel's misconduct, and there's no other word for it, deprived Miss Adika of her right to a fair trial. And whatever you may say about counsel's behavior, simple justice requires at least a new trial. Simply put, throughout the trial, Transit's counsel argued that Miss Adika was lying about where and how she fell. But before trial, counsel had made sure that the jury would never see the evidence that Miss Adika wasn't lying, a prior consistent statement in Transit's own incident report.
Counsel, you're referring to the incident report, I assume?
I'm sorry, I couldn't hear
You're referring to the incident report?
Yes.
Does the incident report say that she fell in the tree well?
No, it says that she...
How does that disprove that it was a fabrication?
The incident report records Miss Adika is saying at the scene she was unaware the ground was uneven. As Mr. Warren testified at deposition and owned up to at trial, the only uneven ground in the area was not the sidewalk.
But the alleged fabrication was about the tree well, and that incident report didn't disprove that.
I don't think it does. It says the ground was uneven. We know from Transit's own witness, the only uneven ground was the tree well, and at trial, when asked, Miss Adika said, I fell in the tree well. My foot was on something in the tree well.
And I understand your point, but during trial, plaintiff's counsel was able to elicit that statement, and so that it was in the record for the jury to consider, no?
Counsel did the best he could with an unfavorable evidentiary ruling, absolutely. And
He got it out. The point is, the statement you are concerned about was now in front of the jury. So I agree with you, it wasn't the best way to get it in front of the jury, but he got it in front of the jury, and they were able to consider it.
Did he, though? Because when Transit says on appeal that Mr. Canavo got out the substance of the statement, what do they say that substance was? Page 31 of their brief, they say it was something about plaintiff having fallen in an uneven area of the sidewalk. The statement says nothing about the sidewalk. It says the ground was uneven. Their own witness said the only uneven ground wasn't the sidewalk.
Is that what plaintiff's counsel said at trial? I don't care what his brief says on appeal. The issue is whether the jury was able to consider that statement. And it was plaintiff who elicited it, correct?
We did our best.
Okay, and so if you didn't get it out the way you needed to, and I don't mean you as in you personally, I don't know if you tried the case, but whoever the trial attorney was, it was their job to get it out, as you say, as best they could, and they did.
The harm, Your Honor, that makes this reversible error is the jury never got to see that this statement didn't just come from Ms. Adika's lips at trial, that it was in Transit's incident report. The jury never saw that.
I'm sorry, this statement was elicited by the witness being handed a piece of paper, right? Say, does that report reflect your refresher recollection, right?
Yes.
Okay, so now the jury knows that she is reviewing from a report, correct?
This is an inferential chain that doesn't remediate reversible error, Your Honor. The jury could have, this statement would have been much more credible if they'd seen it in the defendant's own documents. They didn't. That was error. And it was significant enough, given the confusion in this 1,200-page record as to what that substance was, that we need a new trial.
Sir, just to go back to your first point, the defense counsel's allegedly prejudicial conduct, what corrective action, if any, did you seek before the trial court with respect to that allegedly offensive conduct?
We sought a new trial. We moved under 4404A.
So a post-trial motion
We
under
made a post-trial
4404.
motion, and that was denied by Justice Hagler, yes. Okay. Transit makes a point that we were too late on that because we should have made it before the jury verdict. We submit the conduct here was, in the words of the Birmingham decision, so wrongful and pervasive as to constitute a fundamental error. I'll spare you the greatest hits from this trial transcript, but if I have time left, I'm going to quote one from defense opening. There's absolutely no proof that you will see where she told anybody on that day that this is where she fell and this is why she fell. You will never see it. She was right about that. And that's the error, and that's what requires a new trial. Thank you.
Thank you.
May it please the court, Tim O'Shaughnessy from Transit. The first reason why that redacted information in the incident report is not admissible is that it does not come in as a prior consistent statement. This court has held that—
I agree with you, but you don't think that it's unfair game and poor sportsmanship to then pretend like there's no document that says it the way the attorney on this case did?
Well, in addition, it's not consistent with her trial testimony. Remember, first of all, at her statutory hearing, she said she didn't know why she fell. Now at trial, she's saying, well, I tripped on this—
But most people don't, but go ahead.
Well, now at trial, she's saying she's tripped on this very strange, obvious tripping hazard, metal thing in the tree well. But this little part of a sentence that the plaintiff's attorney is obsessed about doesn't say anything about the tree well, doesn't say anything about tripping on metal. It says something about the ground being uneven. It's not even consistent with what her trial testimony is. As it came out in the questioning, plaintiff's attorney did a very skillful job of putting before the jury, helped by a couple of objections that were overruled, Transit's objections that were overruled, of putting before the jury that that piece of paper, which was a Transit document, he proved that, says something about the ground being uneven. And finally, you know, that it was hearsay. When this first came up in the record,
What's hearsay?
what was hearsay was the statement, alleged statement by Mr. Warren to the bus driver in the bus driver's report. When this first came up in the record, the court said to the plaintiff's attorney, you have not laid a foundation that Mr. Warren had a business duty to make a report to the bus driver. And in fact, plaintiff never laid that foundation about that duty running from on Mr. Warren's part. As far as the alleged improper conduct by our attorney, I think it's plain. Plaintiff made no motion for mistrial. And in the absence of a motion for mistrial, the law is clear, the conduct must be egregious, extremely egregious. And on that note, I would...
Clearly, we have on many occasions frowned quite vociferously about attorneys making statements that a witness is a liar, right? We have lots of case law on that, don't we?
She never used the word liar, Your Honor. She never did that. They're attacking her credibility. At her statutory hearing, she said she didn't know. Now she says she knew. And plaintiff's whole case was to attack Mr. Warren's credibility. And finally, I would note that both in the post-trial motion below and in her brief in this court, plaintiff could not be bothered to itemize the alleged wrongful statements by plaintiff's attorney and cite to the pages where they allegedly occurred. So we agree with the Supreme Court, who frowned upon the statement, some of the conduct of our attorney, but found that it did not rise to the level of requiring a new trial.
Thank you.
If Transit really believes this was an inconsistent statement, then why didn't they try and impeach her with it? Why did they hide it from the jury? There's no hearsay bar to this document. It was a business record. Mr. Daniel put the statement in, fulfilling his duty to complete the record. Furthermore, Mr. Daniel, Mr. Warren, and Ms. Adika, everybody involved in that statement testified at trial. Transit could have cross-examined or questioned any of them about this statement. Instead, Transit tried to keep it from the jury and succeeded. That was an error. Last thing I'll say, I don't know that they didn't use the word liar, but here's the one more excerpt I'll give you from the transcript. Really, what is a recent fabrication accusation except that someone is lying? As I said, page 55 of the opening in the appendix. Remember, this is 2012, 7 years later now. She's going to come more than 7 years and she's going to tell you that this is the reason why she fell? If there are no further questions, thank you.
Thank you. Okay. Miller versus Mount Sinai Hospital. You may proceed.
Good afternoon, Your Honors. Gina Bernardi DeFalco on behalf of Dr. Post and Mount Sinai. This is a lack of informed consent claim. Lack of informed consent is a creature of statute. The statute has 3 parts. The part that we're focused on here is in the 3rd subsection of the statute, that the plaintiff must prove a reasonably prudent patient in the plaintiff's position would not have undergone the treatment or diagnosis had he been fully informed. Defendants proved on their motion for summary judgment, 1, that this patient was fully informed, and 2, that he continued to go forward with the treatment. Plaintiff in their brief has not demonstrated the absence of full information in this patient. This is exactly the kind of patient that the statute forecloses from recovering. He did not rely solely on the words of Dr. Post. Acknowledging that there's a question of fact, even though I think it's overwhelming that Dr. Post did tell him about the risk attendant to this procedure that he was having.
But should we ignore, I mean, I know what Dr. Post says he thinks he said, because we know that the form doesn't say anything, does not in writing disclose the particular risk involved here. But we have the uncle who says that the decision was made because the doctor made assurances that under no circumstances would he remove more than, leaving less than 35%, and thus he wouldn't require additional lifetime treatment. How is that not an issue of fact?
On the first prong of the statute, there is an issue of fact.
Okay.
Now, if you ignore the second point in my brief, which I'm going to rest in my brief on, that there's overwhelming evidence that this was communicated. It was written in his notes that he had an informed consent discussion. There is a piece of paper referenced in the deposition.
There's no specific notation about the risk of a second procedure.
There is an email that was written by the plaintiff's mother on which Dr. Post wrote the number 30% for the risk of hypopituitarism. It's discussed in the deposition, and it's
right, but that's the mother.
No, Dr. Post had a handwritten note on it, 30%. He was asked about it at his deposition. That page.
I understand, but you're talking about an email to the mother. And to me, what's important is the communication to the patient directly.
There are direct communications to the plaintiff also from Dr. Sobel, where he used the number 20%. But again, acknowledging that there may be a question of fact there, this guy, this patient had a bad disease, and he had no good option. And he left Dr. Post's office concerned enough to go seek a second opinion. And in that second opinion, the neurosurgeon told him, if you go forward with what Dr. Post is proposing, you're going to lose pituitary function. And he wrote an email that same day to his endocrinologist saying, if I'm going to go through this and I'm going to lose pituitary function, I may as well just have my adrenal glands taken out because I don't want to lose both. I don't want to lose the function of both. And then she wrote him back. She put in her email directed to him, addressed to him, that there was a risk of hypopituitarism, and then he decided to undergo the surgery. He was fully informed, and he made the decision anyway. And the plaintiff's expert's opinion that continuing on medication was a reasonable option is not borne out by the record. This patient went to 5 different doctors. He had an endocrinologist in New York treating his Cushing's disease. He had Dr. Post. He had 3 different doctors in 3 different specialties at the Mayo Clinic. Not a single one of them thought that it was a reasonable option to continue with medication. It was clear that he had 2 reasonable options, an adrenalectomy or this second surgery by Dr. Post.
Counsel, the concern is what Dr. Post told the plaintiff, not what all the other 4 doctors told the plaintiff, right? Because you can't, I don't think, at least it's my understanding, maybe I'm totally wrong, but Dr. Post can't piggyback on the other 4 doctors' opinions to the, or advice to the patient plaintiff here. I don't think that that's possible. I mean, it's got to be an independent thing that Dr. Post has done for himself. And the claim here is, you know, he talked to the mother, he sent the email to the mother, he talked to the uncle, great. The plaintiff is saying, I mean, the CPR says it's the patient that you got to talk to. So, I mean, this guy, I mean, the patient here, he brought in a lot of support network stuff, but at the end of the day, it depends on what the doctor says to the patient and what the patient understands the doctor to tell him.
I think that we're mixing the 2 prongs of the 3 prongs of the statute. The first prong does put a duty on Dr. Post.
Right.
You know, and Dr. Post, there is enough documentation and there's enough testimony, but be that as it may, he has to go past that second prong, that he would have chose something differently had he been fully informed. And he was fully informed. He is the most informed patient I've ever seen in 25 years of malpractice defense work.
Okay.
This, to me, under the statute, if you pick apart the statute, needs to be thrown out.
Okay, you'll have a minute on rebuttal. Counsel?
May it please the court, my name is Jeff Hine, and I represent Jimmy Miller. Counsel.
Can you specifically respond to the argument that even if there's a disputed issue of fact about whether informed consent was provided, that there was no other reasonable option, which is the second prong of the informed consent claim?
Absolutely. And there were two reasonable options. Both of them are spelled out in our expert's affidavit, Dr. David Kennedy's affidavit. There were two reasonable options. One, he could have continued on the medication he was taking for the Cushing's disease. Now, maybe not for the rest of his life.
So your doctor disagrees with all of the doctors that your client consulted with, all of whom disagreed that continued medication was a true option as per your adversary? Is she incorrect about that?
I'm not sure I completely followed your question.
She argued that all of the second, third, fourth, and fifth opinions that your client got, that every single one of those doctors, none of them said that the best option for him was to continue on medication. So do you disagree with that position, that all of the additional opinions that your client got said that?
They clearly said staying on medication long-term was not likely a good option. They didn't say that's not an option at all.
Okay.
They said it's not a good option. One of the options was you can be on medication, wait a year, repeat an MRI, which at that point may show the tumor and enable the surgeon to go remove the tumor easily. So he had the option of staying on medication. He also had the option of adrenalectomy, removing his adrenal glands. He chose not to follow that option because Dr. Post told him there's no reason to do that. You have no risk here of going forward with the operation. No risk whatsoever. It may not work, but it's not going to harm you. Your Honor correctly noted the law is, the duty is on Dr. Post. He just can't say, well, I saw you in the waiting room reading magazines and looking at WebMD or seeing another doctor. That law is in the record, that it's Dr. Post's duty to correctly inform him. You know, I don't dispute they have an awful lot of evidence to cross-examine everybody. But I'm confident a jury can decide this. And there is triable issues of fact here. I mean, the trial judge wrote an excellent opinion. He nailed the law. They make no argument that there was an element missing from our case. They're just saying that we disagree with your expert's testimony on that element. Not that the expert didn't say it or have a basis for saying it. Your Honors, thank you for letting me be here and thank you for listening to me. I ask you to affirm.
Thank you. Counsel?
Two quick citations to the record to respond to the plaintiff's opposition. 1859 to 1860. These are Jimmy Miller, the plaintiff's own words that he wrote when he was at the Mayo Clinic. After hearing more about the monitoring that could happen with having no pituitary and then getting my adrenals removed as well, I feel it may not be worth taking a chance with having to monitor both. Just have you monitor the adrenals. I think getting the adrenal surgery may be my best option. To this email, Dr. Sobel responded that there was a 20% chance, now we can go through the numbers, but her email said 20%. There was a 20% chance of hypopituitary function, but Dr. Post and I still favor you undergoing the pituitary surgery. The records did not recommend waiting a year on the meds. The records recommended 2 surgeries at the time. Plaintiff's expert's opinion, pages 2008 to 2009 of the record, defends the opinion that it was reasonable to continue medication by saying that after Dr. Post's surgery, after 65% of his pituitary is gone and he's on all these supplemental hormones, he was monitored, he continued on the medication, ketoconazole that he was on before, mixed with something called mitropion in combination for more than 8 years. Here's the expert's opinion. Presumably, Jimmy Miller could have been treated the same way for this time period without having undergone either the pituitary surgery and without having lost his pituitary function. That is hindsight, that is impermissible, and that is insufficient to establish that continuing on the medication was an option or was a good option. He had 2 options, adrenalectomy, which he almost did, and then the pituitary surgery, which he didn't do. There's no proximate cause here. And if you don't have any further questions, I'll stop.
Thank you so much.
Thank you.
Okay. U.S. Bank versus Chait. You may proceed.
Good afternoon, Your Honors. Robert Link, David A. Gowan, Associate Counsel for the Plaintiff Respondent. Mortgage foreclosure actions are not aberrations. The same civil procedure rules that govern all litigation apply in the foreclosure, and that includes the rule that evidence and testimony may be admitted into evidence unless there's a timely objection. Now here, the only opposition...
And we get that, we understand. But do you, as the proponent of the case, have to introduce, dot your I's and cross your T's, and introduce all of the evidence that is required in order to get a judgment in your favor?
Yes, Your Honor, and in this case, we
And did you
exactly
do that?
Yes, Your Honor, we did exactly that. And not only did a referee determine, after looking at the evidence, after getting a chance to review it, after waiting for opposition, a judge decided...
Did you provide the underlying documents that the affidavit of the loan servicer's vice president into evidence? Or was it just the affidavit?
No, it wasn't just the affidavit. Specifically, it was an affidavit, and it was the, pardon me, the Dudley affidavit with itemized calculations that's at record at 160. There's a schedule of arrears at record at 181. And then there was other documentary evidence that's noted in the Schedule B of the referee's report that's record at 183. What happened here is you had a submission by the plaintiff respondent to the referee. In response, instead of filing opposition, you have an email that the defendant appellant sent to the referee, as opposed to filing any kind of opposition. And that email said something to the effect of, we may need a hearing on this, okay? So what happened after that? Nothing. 2 months went by, actually over 2 months, I think it was 2 months and 8 days goes by, nothing happens, and the referee says, okay, I haven't received any opposition. He underscores in the referee's report, I haven't received any opposition. All that evidence, all that testimony is in the record. With that understanding, we make a motion for a judgment of foreclosure and sale. And we provide evidence from Exhibit A to Exhibit Q, the note, the mortgage. In response, the defendant, Chait, files no opposition. The only opposition is the affirmation of an attorney. And that attorney affirmation raises no substantive issues. It's purely 100% procedural hearsay objections that are too late.
Hearsay objections? The bank did not submit the books and records needed to support the request, and you call that hearsay?
No, the appellant is calling that hearsay, and what the court said is A referee had an opportunity to look at all these documents. The court has had an
But that's the
opportunity.
point. The issue here is whether the books and records were submitted into evidence in support of the judgment, right? Isn't
And
that what
according to the referee, and according to the judge, and according to the record, they were. There was sufficient evidence. There was no opposition. That evidence, whether or not it was also reliant on some sort of electronic record, and whether or not, let's say in a hypothetical world.
No, let's not say in a hypothetical world. I think we've got your arguments.
Thank you, Judge.
People versus Cedric Reed. You may proceed.
Good afternoon. May it please the court, Shayna Watrous on behalf of Mr. Cedric Reed. Mr. Reed was never informed of his sentencing exposure or the specific risks and disadvantages of going without a lawyer. The court failed to consider Mr. Reed's mental health status, despite having been told that he needed mental health treatment that he wasn't getting.
What is his mental health status?
He has severe paranoid schizophrenia that he's had for his entire life.
Okay.
Despite failing to perform this required searching inquiry, the court allowed Mr. Reed to represent himself. He was pro se for a significant portion of his
Did
trial.
defense ever ask for a 730 exam?
No, Your Honor.
So it seems to me then that the defense felt that he was fully capable of assisting in his own defense.
But just because someone is capable of assisting in their own defense, courts have said that that doesn't mean that they're capable of representing themselves. That just means that they're able to go forward with an attorney. But here, Mr. Reed fully represented himself. He was pro se for an entire afternoon. He dismissed a juror. He cross-examined 4 key witnesses.
Well, the dismissed juror was someone who he thought he recognized, right?
Correct, Your Honor. But
and when they questioned her, she said he looked kind of familiar.
Correct.
Doesn't that sound like a good idea that that juror not be on the case?
It's just it's a decision that a lawyer makes, and it just goes to the fact that he was pro se, that he was making that decision. So whether or not it was a good decision to make, it was a decision he made. It shows that he was pro se. He was cross-examining 2 of the complainants, a police officer, his parole officer, and he was doing this. He was acting pro se without having had the inquiry that ensures that he understood the sentencing exposure he faced, that ensured that the court
My reading of this record, I had a judge who continuously, several times, kept saying, I don't think this is a good idea for you. You're not doing yourself any favors, Mr. Reed. I really think you should have a lawyer, Mr. Reed. Outside of that, what could the judge have done? I mean, it wasn't like he was standing on the desk and, dancing the jig. I mean, he was asking questions that were pointed. They weren't good questions, but they were pointed and direct to the issue at hand, no?
Correct, Your Honor, but this court has held, and the Court of Appeals has held, that there needs to be specificity. You can't just in generalized statements say, this is a bad idea, it's against your judgment, it's against your interest. This court in People v. Cole held that after a long 20-page colloquy where the court just kept saying, this is a bad idea, you should really have a lawyer, this is a terrible idea for you, this court still said that there needs to be some specific warnings that lawyers have particular training, that he might not understand terms that are being used.
Well, the case law doesn't have any specific litany that a judge has to use, right?
Correct.
So but you take issue with the fact that the judge didn't say, this lawyer went to law school and he has better skill than, he's...
I'm certainly not saying that there was a particular script that the court needed to follow.
Yeah.
However, the courts have repeatedly said that there needs to be specific warnings of the dangers. Can't just say, there's a danger, this is risky. There has to be specific things. So, the court could have chosen different examples, but there needs to be specific examples. Additionally, the sentencing exposure, there wasn't a specific sentencing exposure. talked about. There wasn't any sentencing exposure discussed.
I mean, engaging, given that there's no particular litany or particular script that the judge is supposed to go over, review with the defendant who's considering whether or not to represent him or herself, isn't one of the factors we could consider, the trial court in the first instance, and then us should consider in determining whether a defendant is voluntarily, intelligently, and knowingly going to proceed pro se? Isn't one of those factors the person's contacts with the criminal justice system, and generally and more specifically whether the defendant perhaps has represented him or herself in the past in a criminal action?
Yes, and my client, you're probably referring to, my client had represented himself 16 years prior. We know that mental health changes over time. We know that there were different sentencing exposures in that case versus this one. It was a very long time ago. I draw this court's attention to a Second Department case, People versus Crispino, from last week, that held that even a disbarred attorney, someone who had been an attorney himself, couldn't just waive counsel without this inquiry, this required specific inquiry. Thank you.
Okay, thank you.
May it please the court, Andrew Seawald for the People. Good afternoon, Your Honors.
Good afternoon.
The entire record, as Your Honor has referred to in part, makes it reasonably certain that the defendant in this case appreciated the dangers and disadvantages of proceeding without counsel.
But ultimately, counsel came back in, right?
Yes.
I mean, it was like probably a day worth of proceedings where he was pro se, and then but then it switched back to counsel coming back in to finish the trial, right? It wasn't as if he went pro se all the way.
Yes, that's correct.
So he knew enough, the defendant here knew enough to say, okay, I got to stop what I'm doing.
Well, the context of exactly when the defendant made the request during the trial is important, because the judge responded to the defendant's request in a way that was pragmatic and was specifically responsive to what the defendant wanted to do. The trial had already begun. The defense counsel had selected the jury, given an opening statement, begun cross-examining several of the people's witnesses. It was clear that the defendant had certain things that he was unhappy that his attorney was not asking. And I know my adversary talked about how there needs to be specificity. The judge needs to provide specific examples of the advantages of a lawyer versus a non-lawyer. The judge actually did that in this case, because the judge was aware of the kinds of things that the defendant wanted his lawyer to ask, and she referred to the cross-examinations that counsel had already done, and pointed out to the defendant that his attorney knew not to ask certain questions, that a trained lawyer knows to save certain things for summation, and that's something that a non-lawyer might not know how to do. So that, I would say, was even better than some kind of abstract example that had nothing to do with this case. And then going forward from there, the defendant, I submit, I write in my brief that he actually didn't do a terrible job. As Your Honor mentioned, he was focusing on the pertinent issues in the case in his cross-examination. He seemed well prepared for his cross-examination. He was very familiar with the paperwork, and he was trying to find inconsistencies between what was in the paperwork and what was in the testimony, and he focused on those things. And even if it wasn't, this case was really overwhelming against him. So just because he wasn't able to break the case open and blow the people's case apart doesn't mean that he did a bad job. But nevertheless, to Your Honor's earlier point, he maybe realized he wasn't making the headway that he thought he could make, and then he called his attorney back in. And the fact that his representation ended up being somewhat limited in the case actually helps it addresses the complaint that maybe the court didn't check every box in its colloquy with him when it obtained the waiver, because the Court of Appeals has made clear that when a defendant's representation, self-representation, is limited and he still enjoys the benefit of counsel, then the searching inquiry does not need to be quite as extensive as it might be in other cases where defendant is entirely by himself. And if there are no further questions, I ask the court to affirm. Thank you very much.
I do want to note, just to begin, that it doesn't matter whether he did a good job if the waiver wasn't sufficient, and here the waiver was not sufficient. There were no questions asked by the court, let alone about whether he was taking medication for his severe mental illness. But the only questions that were really asked was, oh, what question did you want to ask the witness? Do you really want to be pro se? Okay, you want to be pro se? Well, I can't stop you. Those are not questions. That is not a cross current of colloquy that the Court of Appeals has said must be present in order for someone to waive the right to counsel. So again, we didn't cover just now the sentencing exposure, which was not covered in the colloquy, which even if everything else was perfect, he needed to know his sentencing exposure. That's a federal and state requirement. So if there are no further questions.
Had there been sentencing, had there been plea negotiations ongoing up until the point that the jury selection started?
There had been plea negotiations, and the only comment that was made about the sentencing exposure during that conversation on the record was that the prosecutor said that he would be seeking more than 20 years, which is, that's not a specific sentencing exposure. That he wasn't told then. That was several days before he waived his right to counsel. So even if he had heard that offhand remark, the court was required to ensure that he knew what exposure he faced when he waived his right to counsel.
Okay.
Thank you. Thank you, you too. Good to meet you.
Yeah.